Greetings. My name is Jeypraba Veerapan and my student ID is 0337587. This is my individual video presentation for Intellectual Property Law module in the August 2022 semester. I will first start off my presentation with a brief introduction on what is meant by intellectual property, as well as the different types of intellectual property. I will then proceed to discuss the principle of a creator of an intellectual property not necessarily being the owner of the property with reference to the different types of intellectual property. This will then lead to a discussion on whether this principle is fair by considering this issue within the context of voluntary assignment as well as employer-employee and commissioner-contractor relationships. First and foremost, what is intellectual property? According to the World Intellectual Property Organization, intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs, and symbols, names, and images used in commerce. There are different types of intellectual property, such as copyright, industrial design, patent, trademark, and trade secret. In simple terms, copyright is the body of laws which grant creators protection for their literary and artistic creations. And industrial design is the artistic or cosmetic aspect of an intellectual property article. Patent can be explained as an exclusive right granted for inventions which provide a new way of doing something. A trademark, meanwhile, is a distinguishing sign which identifies certain goods or services as those made or provided by a specific person or enterprise. The last intellectual property I will be discussing in this video is trade secret, which is a right on confidential information that may be sold or licensed. The creator of an intellectual property is not necessarily the owner of that property. Under copyright law, authorship and ownership are two distinct concepts as recognized by Justice Stephen Shim in the case of Yorkie On against PI Capital Asset Management Sundrian Berhad and another. An author is the creator of a work, while a copyright owner possesses copyright in that work. Authorship and ownership are also two distinct concepts under the Industrial Designs Act 1996, where Section 3 of the Act defines author as the person who creates the design and owner as the person who is registered as the owner of the industrial design. The legal principle here is that the person or body who first conceived and drew the original sketch of the design was the author of the design in question. Under patent law in Malaysia, the general rule is that the rights to a patent belongs to the inventor, and if someone other than the inventor applies for a patent ownership, the request needs to be accompanied by a statement justifying the applicant's right to the patent. Additionally, the applicant also needs to identify the inventor in his patent application. This recognizes that the inventor and patent owner are two distinct concepts, just like the concepts of authorship and ownership under copyright and industrial design. While copyright and industrial design have their authors and patent law its inventor, trademark is established through commercial use. This means that the first person to use the mark in the course of trade and develop goodwill with regard to that mark would be able to obtain the exclusive use of the trademark. Exclusive use to a trademark can also be obtained even if it has not been used before by applying for its registration first with the intention to use it. In trademark law, the creators of the mark are not recognized. Only the trademark owner is recognized as having any rights to that mark. Moving on to the next type of intellectual property, trade secrets are often associated with industrial and commercial activity, and as such are usually owned by business entities. Similar to trademark law, the creator of a trade secret is not recognized by the law. Only the said trade secret holder is recognized as having any rights to that secret. For copyright, industrial design, and patent, the general rule is that the first ownership is usually granted to the author or inventor, although this rule is subject to certain exceptions. One common exception to this rule for the three types of intellectual property is work created by employees and commissioned work. Under this exception, the first ownership of copyright vests in the employer or commissioner. The concept of authorship and ownership is different in the context of trademark as compared to copyright, industrial design, and patent. Unlike copyright, industrial design, and patent laws, which confer first ownership to the creator of the intellectual property as a general rule, trademark confers ownership based on a first use basis as mentioned previously. This was demonstrated in the case of Chongqing Reto Manufacturing Corporation against MP Machinery M. Sendrian Berhad and Trademark Registrar Malaysia, where the defendant's registered trademark was ordered to be expunged because the plaintiff had used the mark in Malaysia first and had the bona fide intention to continue marketing it here. Regarding ownership of trade secrets, there is no general rule which confers first ownership of trade secret to any party. Natural and legal persons have the possibility of preventing information lawfully within their control from being disclosed to, acquired by, or used by others without their consent in a manner contrary to honest commercial practices. The ownership rights to all of the intellectual properties I mentioned can be voluntarily assigned to another person by the owner. In assessing the fairness of the creator of a work not necessarily being the owner of it, I will first look at the circumstance of the creator assigning his intellectual property rights to another person by his own free will. Next, I will discuss the fairness of this principle with reference to conferring first intellectual property ownership to the employer or commissioner. With regard to a creator assigning his intellectual property rights to another person, the option to give property away is an essential feature of any property system, and it is submitted that there is no unfairness or injustice with this concept. Property is primarily about the freedom to either waive one's rights or to retain those rights for the purpose of economic exploitation or plain aesthetic preference. This concept can be linked to Immanuel Kant's idea of waiver and individual autonomy. According to Kant, any definition of a right which includes the necessity of full enforcement becomes a straitjacket, which according to him makes no sense at all. In the context of creatorship and ownership in intellectual property law, fusing the two distinct concepts would constrain the creator to maximal enforcement of his rights with no option to waive those rights. This is undesirable because the freedom of choice of creators must be preserved in support of human dignity and autonomy. A wide understanding of Kant's theories on will and autonomy would include not only a general right to alienate one's property, but also the right to alienate it at a price he sets. Any notion of property, including intellectual property, that does not extend this far fails to fully encourage the creator's autonomy. Therefore, it is submitted that a creator's right to voluntarily surrender or waive his property right must be respected, which is why a creator of a work not necessarily being the owner of it is not an unfair principle. Next, regarding the granting of first intellectual property right ownership to the employer or commissioner, I will examine the fairness of this principle in the context of copyright, industrial design, patent, trademark, and trade secret. Firstly, granting first copyright ownership to the employer may not necessarily be unfair because employees could be remunerated via other means such as salary, continued employment, bonus, and promotion. Other arguments endorsing the granting of first copyright ownership to the employer is that while employers may not necessarily create works, they provide the facilities and materials necessary for creation to take place. It is argued that by doing so, employers make considerable contribution to the creation of new works and they should be compensated. Another argument for granting first copyright ownership to employers is that it serves as an encouragement for employers to invest in resources and infrastructure that helps creators. Next, granting first copyright ownership to the employer or commissioner may not necessarily be unfair due to the existence of moral rights which is recognized under Malaysian law. In the case of Syed Ahmad Jamal against Datuk Bandar Kuala Lumpur, Justice Azhar Mohamad stated that the law grants moral rights to authors to protect the non-economic aspect of work and all persons are under legal obligations to not infringe the author's moral rights. two types of moral rights are recognized in Malaysia. Firstly, the right to be identified as the author of a work under Section 25, subsection 2 of the Copyright Act 1987. Secondly, right of integrity, which prevents modifications of a work without consent of the author if the alteration would significantly change the work and would adversely affect the author's reputation. With the recognition of moral rights, the author may still retain some form of control over his work, even if copyright ownership in the work is vested in someone else. Therefore, the vesting of authorship and ownership in different persons, such as employers and commissioners, is not unfair under copyright law. It is important to note that moral right is only available for authors of copyright works, not for authors of industrial designs. Here, the separation of authorship and ownership appears to be unfair because it fails to give due credit to the author in respect of industrial design, which is seen as an expression of the author's creativity. The features of an industrial design are conceived from the author's intellect, who then gives those ideas a material form. As such, it is unfair to deny him moral rights accorded to copyright authors. Next, similar to copyright law, granting patent ownership to persons other than the inventor may not necessarily be unjust. It is acknowledged that inventors embody their personality in their inventions, and as such, it is only right that they are granted ownership of their inventions. However, acknowledging personhood interests of inventors does not necessitate total inalienability for inventions. Currently, the Malaysian patent law already recognizes personhood interests of inventors in two ways. Firstly, by requiring the identification of the inventors responsible for the invention on the patent application, and secondly, by notation of the inventor on the issued patent. It is submitted that this non-transferable and non-assignable inventorship identification sufficiently protects the personhood interests of inventors. Additionally, the granting of patent ownership to employers is fair because the employee is paid a salary for his work, and in exchange, the employer obtains the benefits of a patent for the invention. Similarly, the contractor is given payment for his work, and in exchange, the commissioner obtains the benefits of a patent for the invention. Additionally, employees and contractors are also entitled to an equitable remuneration if an invention attains an economic value much greater than the parties could have reasonably anticipated, and this right cannot be restricted by contract. However, there are also criticisms to this mechanism because it leaves the employee or contractor at the mercy of the employer or commissioner. It is argued that seeking remuneration through the court system is undesirable due to the time and cost involved. Additionally, it is uncertain what economic value much greater than the parties could have reasonably have foreseen means, which puts employees and contractors at a further disadvantage. A counter argument to this is that the threat of litigation would compel employers and commissioners to compensate inventors adequately for their effort and labor. All in all, it is submitted that the vesting of inventorship and ownership of patent in different persons does not seem to be unfair because patent law recognizes personhood interests of inventors, and additionally, it is a fair exchange between the parties in the context of employer-employee and commissioner-contractor relationship. Regarding trademarks, as mentioned previously, creators of trademarks are not recognized by the law. So what happens if an employee creates a logo for the company he works for, or a contractor is commissioned by a company to design a logo, and the company subsequently seeks to register the logo as its trademark? Who has the right to own the trademark? The employee, contractor, or the company? Here, reference must be made to Section 24, subsection 4, sub B of the Trademarks Act 2019, which states that the registration of a trademark will be refused if its use in Malaysia is prevented by virtue of an earlier right, including under the law of copyright or industrial designs. This means that if an employee or contractor, by means of a contract, owns the copyright in the logo he created for the company would not be able to register the logo as their trademark. However, the more likely scenario would be that the company would own the copyright to the logo if the employee made the logo in the course of his employment or if the contractor was commissioned to design the logo. Thus, the discussion of fairness in vesting creatorship and ownership of trademarks in separate persons goes back to the discussion on copyright ownership, where it was previously submitted that there is no unfairness because employees are remunerated in other ways in addition to retaining the moral right in their work. However, it is not feasible for an employee or contractor to assert their moral right on trademarks because businesses would not want to include the designer's name each time the work is published or communicated to the public. Businesses have an inherent interest in protecting their brand value which they created, so it is not right to include the name of the designer in the trademark. As such, it is submitted that the designer of a trademark not being the owner of it is not an unfair concept. In the context of trade secrets, the question of who owns employee creation was deliberated in the case of FSS Travel and Leisure Systems Limited against Johnson. Here, the court explained that the employer's claim for protection must be based on the identification of some advantage or asset inherent in the business that can properly be regarded as the employer's property, and that it would be unjust to allow the employee to appropriate for his own purposes, even though the employee may have contributed to its creation. Here, protection can be claimed for identifiable trade secrets, but not for the skill, experience, know-how, and general knowledge of the employee. This approach to ascertaining ownership of trade secret is not unfair to either party, but it is submitted that it needs to be further refined. It is not disputed that employers or commissioners should have a right in the trade secret because the employer or commissioner provides the infrastructural nexus for such creativity to take place in the form of wages, equipment, location, and the general sense of direction by which creative ideas result from. However, there must be a balance between the freedom of contract, business ethics, and private economic freedom of employees and employers. In improving this area of law, reference can be made to the South African case of Northern Office Microcomputers Limited against Rosenstein, where the Supreme Court held that the protection accorded by the law of trade secrets in the context of ex-employees should be limited, and that all that should be protected was the employer's lead time or the advantage the employer has in getting his product to market first and nothing more. The court added that if the employee was engaged specifically to produce that information, this could amount to a trade secret, although it is no more than the result of the application by an employee of his own skill and judgment. It is submitted that such an approach is fair and would balance the interests of employers and employees or commissioners and contractors, although it remains to be seen on what kind of approach the Malaysian courts will take with regard to trade secrets developed by an employee or contractor. In conclusion, the principle of the creator of intellectual property not necessarily being the owner of the property is overall fair because creators should have the freedom and choice to waive his rights if he wants to in support of human dignity and autonomy. Regarding employers and commissioners being granted first ownership of intellectual property, it is submitted that this is not an unfair principle within the context of copyright and patent because there is a fair exchange between the parties. However, this principle is unfair in the context of industrial design because moral rights are not accorded to authors of industrial designs. Additionally, even though the moral right of trademark creators could not be acknowledged, this is not unfair at all, considering the nature of trademarks, which are closely related to the brand value created by businesses. Lastly, regarding trade secrets, it is submitted that the principle of the creator of the secret not necessarily being the owner of it is not unfair because employers or commissioners provide the infrastructural nexus for such trade secrets to be developed. Thank you for listening and have a nice day.